Call to order the meeting of the December 7, 2016 Planning Board meeting for the City of Caribou. First item of business is approval of the November 10 regular meeting minutes. Do I have a motion?
Make a motion that we accept November 10th meeting notes.
With one slight amendment, we do need to scratch Steve Wentworth, sorry, Todd.
Oh,
I wasn't sure if
I
he was
didn't
here.
even catch
so-
that.
so.
It was not there.
okay. Is there a second? Michelle?
Yeah, I with edit, yeah. I
Okay.
second with edit.
Moved and seconded, we accept the minutes with Steve Wentworth's name removed. All in favor? Any opposed? No. Unanimous? Okay. Under item 3, new business, presentation from Leo Trudell, Executive Director, Safe Alternatives. Discussion regarding submission of a site design review application for the operation of a medical marijuana dispensary. Mr. Trudell,
Yes, sir. How are you?
welcome.
Thank you. I'm here this evening to request that our proposal application be accepted. It's my understanding that you put in a moratorium after the fact. The application was submitted on October 26th, and the moratorium went into effect on the 14th of November, the 26th of October, I will say. That being said, upon a closer look at your moratorium, it seems to me like it's specific to recreational. We are the only, and I repeat, the only registered dispensary in all of Aroostook County, which is District 8. Unlike some other institutions or places that you know that are running in your town. I did bring counsel this evening in order to answer further questions, as well as Mr. Emper, who is the Chief of Operations for Safe Alternatives.
Okay, is that the extent of your comments for right now? I don't want to cut you off before we start asking you questions.
Well, we also have other members in the audience that are pertinent to this discussion. One is Mr. Willett, who is the owner of the building that we've secured. And there's also patients here that may or may not want to speak on our behalf.
Okay. I guess this is new territory for me at least. You submitted the application on October 27.
26th, I believe.
The receipt was dated the 27th, and that's what I went with as far as the
Alright.
date, and I don't
The
have
question in my mind is, was it acted upon? Was it deemed complete at any time, or was there any activity on it by this body, or was it just an application pending?
if I may. This was the application package that was brought to my office by Mr. Trudell, and I passed it on to Ms. Thompson. Had Mr. Trudell go down and visit with Penny Thompson, our building official, and building, correct me if I'm wrong, I believe Penny assisted Mr. Trudell in going through the site design application form that's contained within the document to help him complete some of the incomplete lines. Is that accurate?
Sure.
So, after that, Penny held on to it and then passed it back on to me.
Actually, if I might interject, it actually went to, I believe it was your town clerk, who actually took the check.
Oh, right, yes, we received, he made out a check, and I don't know if they signed this, but we do have the receipt for the payment that he made of $640. Site design application fee of $590 and a sign permit of $50.
And now this just to have some clarity, you already had / have an ordinance on the books specific to medical marijuana. And I say that because I assisted your city council with that 6 years ago.
Okay.
Well, let's not put the cart before the horse. What was, Jim, what was the date that it was deemed complete
as far as the site design review and everything like that.
Well, I haven't conducted any review of this material at all. I have not looked at this material. Penny helped him fill in the missing blanks, the blanks that were not completed on the site design application, which is our form that he completed with Penny's assistance to make the application sufficient for submission and the fee at that time.
Okay.
But since then, we haven't processed it, we haven't done anything with it at all.
And
And I have not read it.
And I
So,
might also add that I requested to be on the November
Agenda?
agenda, thank you, sir. However, I was told that I couldn't make it because of
There's a time frame.
timeframe,
the time frame.
right. And then subsequent to that, the council held the meeting on the 14th, passed the emergency moratorium, set the public hearing date for the 28th, passed the permanent moratorium, and both those things have occurred. And I provided you with the staff report that Mr. Blees, the manager, provided to council for those two meetings and the documentation that was used for those two meetings. The documents you have are the documents that were eventually signed by council. I don't have copies of the signed version, but those can be produced if needed.
But my question is, and I went through the package that you sent out via email as best I could, and I became very confused. Because we have two issues before us as a community. One is medical marijuana dispensaries, of which one is already established. I don't know if it's up and running, but I see it every day when I go by it. THC.
If I might correct you.
Let me finish my question. And so in my mind anyway, that's one issue, medical marijuana dispensaries. And the other issue is what I believe the city council, they can correct me if I'm wrong, was addressing, which is marijuana dispensaries without the word medical as a result of the recent referendum. And I think these are two separate issues, in my own mind anyway.
Would you, thank you. I think you were going to correct him that THC is not a dispensary.
Well, THC is not a dispensary, and neither is the one behind Dodo's.
Which I'm not aware of. Would somebody tell me what THC is?
Tetrahydrocannabinol.
Yeah, I know that. I mean,
It's the health clinic.
what's the facility?
Oh,
What does it
I
do?
am
It's where
It's a
sorry.
physician.
It's where he goes to.
It's a doctor that
Get a medical
issues
marijuana card.
Dr.
prescriptions.
Ortiz.
Oh, okay.
He'll issue you a medical marijuana.
So it's
card,
not a
if I'm
dispensary?
correct.
No,
Oh,
it's
that's fine.
correct.
where you get the prescription to go to the dispensary.
Okay, as far as behind Dodo's, I never heard of it.
Now, help educate us. My understanding regarding the medical dispensaries, I mean, we've been made aware of medical providers who are private individuals who are able to take on a limited number of people that they grow and service, whereas the dispensaries are larger scale operations, and there's a restriction of X number in the state of Maine. Now, I thought there was one established for Worcester County in Eagle Lake.
That's us, sir.
Oh, that is you.
Yes, sir.
So now are you looking to relocate or add an additional one?
Just add a retail establishment. Relocate. To relocate the dispensary only, not the grow facility. We
Okay.
have no intent of growing in Caribou.
So you're looking to, okay, so now as far as what rules or laws apply to your scale of dispensary, that is permitted to relocate the,
Correct. Yes, sir.
and does the state have to grant you permission in doing that?
Yes, they've already visited the facility. And I have the new certificate as of today.
New certificate which
From the
grants,
HHS.
which grants,
Which grants us the ability to be able to do business for the next year.
in Caribou,
Actually, within District 8.
which encompasses Worcester County or more,
Correct.
more than?
All over Worcester County. Technically, we're allowed to cover the entire state. However, our district is District 8. And that was the way that the state determined that they were going to allocate dispensaries going forward. And this was 6 years ago.
Okay.
So, in my mind, how does a dispensary work today where it's against the law to go and buy marijuana? normal person to go buy marijuana?
That's a good question. So, an individual may have some sort of debilitating ailment. They end up going to their doctor, right here in town might be one of them. They end up, as a matter of fact, and you have a regular physician that does a very good job right here in town for assisting patients that are on much heavier medications such as OxyContin and moving them off of those. That being said, they go to their doctor and they get a recommendation. With the recommendation, that's a card, they come to a dispensary and they end up signing a designation form that's provided by the state, allowing us to grow for them. In addition, they go through an orientation of how to use it, what to use, when not to use and what not to do, don't drive, don't operate machinery, what have you. That's all part of the operation. They leave the card with us and then they're allowed to purchase.
Do you offer for sale different varieties with regards to different medical diagnoses? My understanding is there are many different strains available, and certain strains are better for certain diagnoses.
Yes, sir, we do. And as a matter of fact, we even have, right, as of today's count, we have 4 strains that are known for high CBDs that have no psychological effect or psychoactive effect, and are strictly for body relaxation.
So they're medically helpful without being stoned,
Correct, correct, yes,
to put it in plain English.
yes.
I thought that the state regulated the number of dispensaries.
They do. There's only 8 allowed.
And he's one
We're
of them.
one of 8,
And you already exist.
yes.
What we're saying
And
is he
have a
wants to
place.
relocate.
Right.
The retail, the storefront.
Correct.
And I can understand that, because Eagle Lake is not what I would consider centrally located in the region.
Yes, sir.
That's understandable. Jim, do you have anything, or I'll look at my other members here, regarding the existing ordinance that is on the Caribou books regarding medical marijuana?
I provided that in your packet.
Oh,
It's pages
Gotta get
428 through 431. That is the current, and I have the code here as well, but this copies of those 4 pages are in your package. And there's no mention in our code of the word marijuana or cannabis. It just simply talks about dispensary and registered cultivation facility. This is the code section, unless someone in the room perhaps can tell me otherwise.
I think that would be otherwise. Pretty sure when I wrote the ordinance, we did reference marijuana,
Okay.
and it would be directed towards medical marijuana
Mhm.
solely.
But if it's,
Looks
if
like
it, if it's not spelled out, then we have to go by the definitions, I believe, of what was done at the last council meeting, if I'm not mistaken.
Well, we gotta be careful.
yeah.
Steve, is it not the 4 pages that I provided to count the members of the planning board? Is it somewhere else? Because I couldn't find anywhere in here.
Should be right in the chapter 13.
I
Yeah.
can't find it in chapter 13 at all.
I looked through chapter 13, did
Yeah.
a word search with, MS Word in the Word document format.
One of the, towards the rear, I would guess being that it had been just added in sequentially. Yeah, this doesn't even look familiar to you, Jim.
What's that?
Do you have a copy of the code? Usually
Of your code?
Yeah, of our code?
It might actually be on the front cover of my application. Is it on the inside front cover? Because I found it. Maybe not. Maybe I pulled it.
I have here, all I have inside this document was a copy of our ordinance that we
Okay.
just passed for the prohibition. So,
I don't believe we even ever went over it for
I was gonna say, when we went through 13, yeah.
We never went over it.
No, we didn't, in our
Never
review of
got-
13, it was not in the material that we
It
reviewed
didn't get in
as
this,
part of the chapter 13
it
review.
didn't get inserted into the notebook before, when we
Was
started
it-
reviewing it.
Um,
I'm not prepared to say that 428 through 431 don't exist, I'm just,
Oh, no, that's in our code.
Yeah.
Those pages came right out of our code book. So it's just, I thought it was interesting that I couldn't find the word marijuana in the code, and that the only thing I could find with regards to dispensaries was that citation that I gave you right there.
pure speculation, maybe council decided to excise the word marijuana and change it to nonprofit for whatever reason.
But that code section was adopted in 2010.
Which unfortunately is before the time of everybody on this board.
And myself, but we have two gentlemen in the back that have knowledge of that time frame from Caribou.
What say you, Mr. McDonough? Anything? Do you recall enacting this?
I think I recall generating the product and sending it forward to the council for enactment.
Oh, you weren't on council then?
No.
Okay.
Jim, was that during your involvement?
I wrote it.
Okay.
We addressed issues as location, proximity to such things as churches and schools, I believe. This is not what I wrote, Phil.
This is not what you wrote.
There's no mention
And
of,
I worked with Chief Cahagan and myself, worked on it. We had a decent ordinance, I think. We passed it forward, so could be that somehow things have changed since I retired. This doesn't even sound familiar to me.
it doesn't mention location, it doesn't.
No.
No, it didn't. But it was the only thing I could find in the code that had anything closely related to the word dispensary. And that's what when I couldn't find marijuana, that's what I started looking for. So that's why I presented that to you, is what I believe to be what we were dealing with and what Mr. Trudell was referring to when he said he was going to abide by our existing code.
I know I read the code.
Okay.
I know I read it. And,
I'm not going to dispute that.
And I know that my application meets the letter of the code.
I think we have a situation, the code that you recall reading had the word marijuana in it.
I believe so.
Medical marijuana dispensaries.
I think we have a situation that we're gonna have to send this to the municipal legal counsel to give us direction, because we've got a couple of issues here. Number one, what does the city have for an ordinance regarding medical marijuana? And what effect, if any, does the moratorium that the city council implemented have? And I mean, we don't want to act in any way that we shouldn't. We want to be law-abiding as you do. And I know that this causes a delay, probably, but I don't know if we could send this to Rick Solomon for him to review. I believe he's still a city attorney.
Yes, he is.
We have another question for him related to that. Since this application was received prior to the enactment of these moratoriums, do they affect it?
It's all right.
It
In
hasn't
other words,
been brought before us, though.
he's got to look at the global issue, look at every angle of it, and maybe even consult with Mr. Trudell's attorney to look at, so that the two parties can discuss the situation. And
Come to a resolution.
yes,
I'd like to defer to my attorney.
I have some additional questions. I don't know if I have very many answers, but I have some questions for the planning board. I had a chance to review the several pages that were cited by the city manager, and those are the ones that are currently with your ordinance book, would authorize the type of business that's looking to be transferred and relocated from Eagle Lake into Caribou. The moratorium seemed to be awfully specific to the passage or the not passage of what was being presented by the referendum at the last election. And I think the action taken by the town was looking to make sure that they're gonna be able to handle whatever direction that vote went, whether it was a yes vote or a no vote, and things weren't just gonna turn into a, citywide dispensaries for recreational marijuana. At least that's what I see when I look through the main townsmen and the other ways that it was considered and referred to. But what I did earlier was, I looked at Title 22, which is under the main laws specific to dispensaries that are on the books and that are authorized. And there's a specific section, and I'm going to leave you a copy of this. I want you to look at paragraph 10, and I only have one copy that I can share, so I'll let you guys pass it around. And it says, local regulation of these dispensaries. This chapter does not prohibit a political subdivision of the state from limiting the number of dispensaries that may operate in the political subdivision, or from enacting reasonable regulations applicable to dispensaries. That's what you've done with your ordinance already, which we have a copy of. A local government may not adopt an ordinance that is duplicative of or more restrictive than the provisions of this act. An ordinance that violates this subsection is void and of no effect. So we'd suggest a moratorium in regards to the application that Mr. Trudell, on behalf of Safe Alternatives, has done. That moratorium is void in regards to his dispensary for medical purposes.
I'd like to be able to give this to you so you guys can read that paragraph 10.
This is a touchy subject all around though, because it's not, you can't, when we pledge to abide by the rules, even in coming in this planning board, we pledge federal and state and local. We don't, and federally, this is still a Schedule I drug that's illegal. So it depends on which side you're falling on and which laws you're looking at as to whether or not this is here
Bring
or
up
there.
A good perspective, something that I'm familiar with, especially where I practice law up in the valley. We have a lot of border patrol agents that are stopping cars, whether it's for assisting local police departments or otherwise. And a medical marijuana card isn't going to carry muster with them if there's any marijuana that's crossing the border, because they've got their federal rules. But I'm also aware that they don't turn that into their job number one because the way the state has lined up on the marijuana issue. I don't know what they're going to do with the recreational use. I just know that they have not come in and stopped the business in Eagle Lake because they say that it's inappropriate or somehow violating federal law. If they were to be taking that hard action, they would have done so already. It's been there since what year was it?
2010.
Since 2010.
And at that time, did Eagle Lake have any ordinances on their books with regards to it?
I don't think they did.
They still don't.
Okay.
As a matter of fact, when they heard that we might be moving, they asked us not to.
It's in there.
Different page.
Yep.
We're,
In here.
number 39.
Does anybody else need?
Number 39, registered nonprofit dispensaries and registered cultivation facilities for medical marijuana.
Anybody else?
Page 891 and 892.
Do I want me?
My apologies for not finding this. It was not in the document that I did this word search on, so apparently we need to update our code.
You mean the master book?
But yeah, right.
Okay, here's the chapter 10. Let's not conflate the two
Yeah.
documents.
No, but I also, I have an online version that I searched, and this didn't come up, so.
Is your organization nonprofit?
Yes, sir. And I have a copy of our status, our current nonprofit status in the application.
Nonprofit, is it a 501c3 with the IRS?
No, it's not allowed to be.
Okay.
It's
State
a
of Maine Corporation.
Yes, it's a main nonprofit corporation.
It couldn't be 501 because it's federal.
My quick review of this, it seems to track what I'd seen under state law.
You understand our desire to run this past the city Caribou attorney to make sure that we don't violate anything before moving forward? Pardon?
We don't oppose it. I think that's the reasonable. one of the things that I suggested when I showed you Title 22, paragraph 10, is that you're already in violation by stopping it where you have this ordinance on the book. And you're saying there was a moratorium you're trying to put in place that would affect this application.
Let's not conflate the two issues. That's what I'm trying to keep them separate.
My understanding of number 10, I thought it made reference only to local ordinances that were more restrictive than the law. You
Correct.
can still have an ordinance, it just can't be more restrictive.
Well, when you stop the ability to apply for something that's currently on your books, you become more restrictive, is what we'd be presenting.
Right, but we haven't done that yet. We're discussing the process.
We haven't even determined the intent of city council with these moratoriums.
I don't have a signed copy. Was it signed and put into fruition, or is it
That's
just?
up, Mr. Chairman.
No, it is, yes. Like I said, I mentioned that these are the unsigned copies that were provided to me by the clerk, but this document is in force. It was signed, it was. Yeah, it was signed by the council, and the documents that are signed are certainly available from the clerk's office.
Now,
We can
Mr.
produce those if we need to.
Mr. McDonough, you were on council when these moratoriums went into effect.
That's right.
Do you recall any discussion of including medical marijuana dispensaries in this ordinance? This moratorium?
I didn't discuss it, and I'm trying to think. I think there was a participant from the audience that talked about it, but I don't think there was any further discussion after that.
So it may be
I
that,
think the smart thing to do would be to check with legal counsel, and I think he understands that we're not in a legal position to see who's right and wrong.
Right.
Let's iron that out and then go forward. You know, I think in all fairness to everybody.
yeah, it's just a question of intent. No one here seems to,
The way I
Wanna go on the
interpret it is they're looking at dispensaries, and unfortunately, I think I understand the divide, but that's at the legal discrimination, not a lawyer.
So then, would I have a motion to defer this, or is a motion even necessary, Jim, to pass this over to the Caribou City Attorney?
No, I'm happy to take your direction.
Go ahead.
Set up a meeting with.
Do we have to have a motion for that? We didn't really have anything on.
No,
the table
that's
for
what I'm saying.
discussion.
I don't need a motion to follow up on that.
What zone is this property in that we're gonna be renting? Because that,
Is that right across from your shop?
Yes.
yes, it's very
well, everybody's talking, the shop, what shop?
It's
Sullivan's
a
Floor.
business district.
Is it
Oh.
an existing building? Is it the former daycare?
Yes.
Former Circle of Learning.
Zone's
Bud Ayers
RC2.
building of years ago?
RC2 is a zone.
RC2.
Okay.
It's a freestanding building.
Let's
very
not
easy
keep it a
to hear, very
secret.
easy to monitor.
Yeah.
And as it's written, I mean, on page 892, it says no certificate of occupancy shall be granted for a registered nonprofit dispensary unless the structure providing, okay, no, I misread that, I'm sorry.
Yeah. That's one of the allowed zones.
Well, I think out in the country, I mean, you're not within schools, you're not within a lot of things.
Now, according to the code that we found on page 891, 892, the zone is correct for this use.
Yep.
Okay. So, I think Steve had a question first, then I'll,
Yeah, I'd like to mention that the sheet that Denise had passed out a few minutes ago,
you were.
That's the
is
one
that-
you wrote.
that's the ordinance that I wrote back when we had the first need to have an ordinance on medical marijuana.
Yep. Okay.
So this is familiar.
I have to question whether this other one is even valid.
Mr. Trudell?
What I'd like to say is, we went to great lengths in order to turn in a completed application. I think if you take a look at it, you'll find that it's about as good as you're going to find. And if you have any questions, by all means, you have my contact information, Jim has my contact information, and I'm more than happy to answer any questions, as well as our legal counsel or Mr. Humbert.
Okay. So, are we all set with this issue?
We have to be for now. We don't have
Yeah.
another.
Well, I just want to make sure there's no other,
I would like to have the city's council, not the city council, but the attorney, city's attorney, get this resolved as quickly as he can, because I think there's a site plan approval application on the books, and I don't think we should dilly-dally around having a hearing on it.
I'll reach out tomorrow.
Appreciate it.
Try to set up a meeting with Mr. Solomon as quickly as possible.
Yeah, tell them it's high priority. Okay,
I'll be in touch with you gentlemen. Let you know what
Thank you, everyone.
thank you.
As soon as I find some progress. I mean, when I set a meeting and have a meeting, I'll let you know. Mr. Chair, apologies for that, not having the right section.
Well, it's a confusing issue. Jim.
Well, no, but it was not in the document that I was given when I was given chapter 13 to do the review.
And
So
I
that's
think-
why we didn't review this.
Yeah, I think,
It was not in the material that
Right.
we reviewed when we
Right.
were doing that review in the summer. When we left off in the summer, this is not something that was in that document.
That's right.
But it's obviously been on the books since 2010.
Thank you.
So that means we need to relook at what we were
It makes
reviewing.
me
Well-
wonder, where did this come from? Because it says it was adopted in October 2010. This other one.
I don't know. That's in the code.
one of
But
the,
no,
It's in a different chapter.
it's just in a different
That one's
chapter.
in a different
Yeah.
chapter.
I think that part of the review that we're embarking on with your predecessor was trying to bring some organization, because I think things were kind of scattered around. I was
Oh, they are.
I was quite disappointed when I first came on and was emailed a copy of the current that I spent well over a weekend reading, only to find out that it was not the current copy. And so it appears to me that it's been saved as a Word document. I don't know about under different names, but at different times. And there might be 3 or 4 or 5 different files, Word files out
On
there.
various computers.
Conflicting versions.
And there's not
Right.
one single prominent,
I have
you do have
it,
it.
yes.
Okay, can you,
I've been here 18 years, so I have the file.
okay.
So if there's other ones out there,
I would-
that's not something
Yeah.
that
I would ask,
okay.
I would ask that
Could
you,
Because
could you save that document with today's date in the
Yes.
file name?
I would delete what you've got.
I was
It's on
gonna-
the
Right, that's what I'm
P drive.
asking.
I was
If
gonna
you would
It's on the
send that
P drive.
document,
That
if you
one
would-
is
if you would send that document to me with a file name with today's date on it,
Yes.
then I will know that it is the document to use going forward, and
why
I'll
would-
circulate that.
Why wasn't it in here then?
And
well,
I
because,
have no idea
We don't- I
what
don't know.
you have.
I
would have to look
I'm
at it. It
working
could
with
have
what
been
I was given when I arrived a year
thing,
ago.
I don't know.
yeah, well,
And we have
Right.
had so much changeover. You have to remember this. I've been here a long time.
It's
We've
embarrassing.
had so,
I apologize.
Yeah, sometimes.
Actually,
Yeah.
And
Well,
we're on camera, aren't we? But there's been so much changeover with these duties and different people and different offices and this and that. So if you want the right document, just ask me.
I would,
I have it.
I would.
I would like the right
I-
document.
You know what I mean? Just ask. I've been here so long.
Can
I
you-
haven't moved.
Yeah, can you, can you email us that document also?
I certainly can.
Just
It's
send it to the-
really large, though.
It's
I
a
think I
big
can.
file.
Is it
I
a
think
Word
if I
document
It
or
might
is it a
take you a
PDF?
couple hours to
I can
download
do
it.
both.
Well,
I'd
maybe,
like it in Word.
what about copying it onto some thumb drives or flash drives? I mean, if you need, I'll
Whatever you would
provide.
like.
We can put it on CDs, whatever the most convenient.
Well, I'll
form
provide
is
you
for-
some flash drives,
Sure.
And,
I've got a couple too, if you-
because that way it's portable, it's easy, you don't have to email a large document, etc. And then instruct all city employees to delete any other version they have.
Yeah, it's just get rid of them, throw them out.
Which document are they talking about?
The particular chapter 13
Right here.
in city code, the zoning,
The city code.
they only have the zoning one. They only have,
I have that page though. I did end up having that
The,
page in here.
The
you
updated
do? I
document-
didn't see it.
Yeah.
The
You're like
updated
missing a
documents
page.
are on the webpage.
You hope.
Yeah, but evidently not.
Yes.
all.
We found an instance where one of the documents on the website was not updated. So we found that
Okay.
together. So,
And then,
and she was gonna make an update, so. Remember,
Okay.
I think it was a land use table or something about the land use table that needed to be updated.
I don't can't
So,
remember that.
yeah.
But
That's broke, that needs to be fixed also.
That's for
Oh,
sure.
absolutely.
what needs to be fixed?
The online version.
Those should be fine.
Okay.
Yeah, those should
Well,
be
it wouldn't
fine.
hurt-
Whenever I do it, I have this whole thing that I do, and there's certain places that it goes, and it's in PDF, and it's in Word, and I have to go through this whole rigmarole, making sure they're all updated, and the website is one of them.
Did they get the black book?
No. That changed years ago. I think Lisa was the secretary, yeah. And then if there's updates to it, sometimes people don't update their ordinances.
Right.
Sometimes I send out an electronic copy or paper copies, and it's up to the people to put it in their books. And it
Okay.
doesn't make it.
That's a procedure that usually doesn't work.
I have a
Yeah,
question.
so we can do all new if you
When-
want.
When something
Yeah.
goes to public hearing, what is the point of the public hearing? Like, if the public comes in and says, you know, yeah, it's all well and grand that a site plan has, you know, come forward for, you know, D-Rock Bar, but we don't want that here.
Uh-huh.
Does that make any difference at all?
Sure it does.
Well, I mean, the purpose of a public hearing is because, first and foremost, whenever they're required by statute, it's usually because the state statute has dictated that for whatever reason, a public hearing is going to be required for X, Y, or Z, whether it's a liquor license, whether it's changing a city code, reviewing a site design application. There's a variety of reasons why a public hearing is required, because part and parcel of a public hearing is public notification. So we're required to make notifications to adjacent landowners, publish it in the newspaper within X number of days prior to the public hearing,
But at the end of the
post
day,
it
it
in
matters.
places that are incumbent.
Rest in order to approve.
Right,
You
and
could
that's
have
what I'm
50 people
asking,
come
so
before
if
you
it's,
opposed to something, and you could still pass it.
so if it's written here though, like, oh, we allow it here, 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 and here, and then you have your public hearing and they're like, hear ye, I don't think so, then the public can win over that even if it's written here?
Not necessarily.
It's up to us.
You need to make a change.
We have to, we as a planning board have to enforce the existing code. And if it's allowed, say in a particular location, and there's no other reason why we shouldn't approve it, we have to approve it. But there was an instance last year where someone wanted to establish a facility, I think for some handicapped people, or needy people, and we could have gone either way on that. We had the power to say, yes, you can do it, or no, you can't do it. And neighbors objected, and we wound up saying, no, you can't do it.
You're talking the place on
Yeah, I know
on
which
Vesta?
one, yeah.
Or on,
Up on South Main.
up off South Main? But that was, we couldn't by code.
Is that true?
That's true.
Right, we couldn't because it was
Okay.
on the first floor and it was only allowed on the second floor.
Correct.
All right, never mind.
I think that the public hearing enables this board to learn where a person who has an operation and wants to establish a second location hasn't maintained what was supposed to be done at the first location, things like he doesn't abide by the noise levels, he doesn't abide by keeping things behind the fence, et cetera, et cetera. So even if it's allowed, if the applicant has a track record of not abiding by the limitations, then we would have valid reason to say, no, you've proven to us you can't do it right where you are now, why should we allow you to expand any further?
So public input matters little to the written word. That's what I'm asking.
No, what I'm saying is it does matter because public input is how we find out.
It matters where we have discretion. There are some issues where we do not have discretion.
Change the code.
And I guess I would interject that this city code is ultimately passed by the city council, which requires public hearings in order to
Right.
make changes to the city code. Amendments to the city code require public hearings. And there are instances, particularly in this case, where even the city council is going to be constrained or limited perhaps in the language that they're permitted to adopt into their code because they have to be in accordance with state code. And that's where in this instance, the state code is very specific about what it is allowing through home rule the local ordinances to do or not do. And I had read that language, outside of our own city code, I had read that language elsewhere in some of the legal opinions.
Are
So-
your microphones on? Is this still being?
Oh, yeah.
Oh,
Yes,
yeah, this is a
sir.
public
Yes.
meeting. Yes.
Is
We're
there-
being filmed and
We're
recorded.
not allowed to discuss some of these things outside of being in the meeting, or we're,
No, you can
Considered
hold
in a meeting.
workshops.
Yeah.
Okay.
And a workshop would be the appropriate and best time for the board to get together to kind of go over procedure, the cans and can'ts of being
Okay.
on a planning board.
Mhm.
JCAM is the local senior planner at Northern Maine Development Commission. I think you could have Jay come in and do a nice presentation, give you a good chance to ask questions, work out,
Sure.
so that it all makes sense. But primarily, the public hearings are so that the public can sit here and hear, not so much that what the public says to the planning board. Planning boards are to look at the application, and if the applicant has met the criterion, it's the charge of the planning board to approve that based on the ordinances in place. That's where you try to avoid, you know, emotional or how you feel towards a person or past activities. It's the application before you at that time. And if it does look like there's, it could go either way, the training from the state planning office and all is that boards should try to rule in favor of the applicant when it's a tie. So when you do a review and you get down through the list of the elements of the criterion, when you get to the bottom of your columns, if you have more pluses than more negatives, the project could possibly pass.
Jim, yes, you're right.
Yep.
I hope this helped. a little.
Where the
Okay,
public
thank
input also is helpful sometimes if we feel we're in a situation where we want to put conditions on approval. Those conditions may be triggered by public input.
okay.
Where you have that discretion and latitude.
Yeah,
Absolutely.
sometimes we do, sometimes we don't.
Right, right.
Jim, do you happen to know, just with regards to the whole marijuana thing and what the council approved, did that go to Rick prior to? Have him
I do
bounce
not
out?
know that. I have no idea if Mr. Blees used our legal
I don't know
counsel
if he did.
for that or
Well,
not. I don't know.
I suspect he may have relied on municipal associations' counsel and direction, because the whole state was in the same situation, and what I've read is that this whole recreational marijuana use is gonna take pretty near a year to get the rules on the state level fully established for Department of Agriculture or whomever to get everything organized.
Right.
Okay, moving on to old business. Chapter 13 revision. I believe this is a request by Member McDonough to, well, why don't I just turn it over to Phil to tell us what this is.
When Dr. Ortiz came to us and wanted to add a second apartment to his dwelling upstairs, I think given the greenness of the board, we didn't necessarily read into all of what we were discussing with him, especially when the topic of parking came to fruition. And I believe that when he initially turned that into a residence back in 2012, he said that he was going to have 2 garage doors, or 1 garage door, I believe, installed off of, into the rear of the building, and say across the street from Napoli's. When we discussed parking with Mr. Ortiz, he said that he agreed with Gary St. Peter, who owns Napoli's, for 2 spots, which would cover his parking area. In theory, and given the way the code is written, it doesn't jive, because he's supposed to provide provide 1 off-street parking spot separate from his customer's parking spot for his business, which had he put his garage doors in there, he probably would have been okay with that. I think what we need to do is readdress this particular issue and give him ample time, exorbitant amount of time, but in order to correct this, and we need to note that this particular property right now is a non-conforming use. It's allowed by us, which I think I voted against that particular thing at that time when we had that hearing. Based on the parking aspect of it alone, it's non-conforming.
What, can you, my recollection is that we determined that the 2 spaces that he had available from the restaurant across the street satisfied the
Well,
parking requirement, so I'd like you to
I think-
show us
I think
why it
I
doesn't.
think the majority of the board agreed, but, let me see if I can find it here.
I think I remember him saying that he had a signed agreement with
Yeah,
Gary.
but even if he has a signed agreement with Gary, it won't work because, if you look at page 899, it says in addition to the required I don't think he printed off the page, but it says in addition to the required off-street parking, the restaurant, being Napoli's at this particular point, 1 parking space per 3 seats based upon the maximum seating capacity. He doesn't have that. So
Who's the he?
Napoli's does not have that. He doesn't have,
On their own property.
he doesn't have enough of that on his own
There's a
property.
municipal lot next door.
Correct, but that doesn't apply to that. They need to provide those spaces. And if Gary is gonna provide spaces to Dr. Ortiz, he's taking away from those spaces that he has available to him to provide parking for his customers.
Wait a minute, back up a minute.
Sure.
You said that the public parking lot next to the restaurant doesn't apply.
Correct.
Why not?
So you're telling me that everybody that's in the downtown mall is in violation because they don't own the parking lot?
No, I'm talking with regards to the residence aspect
Yeah,
of
but
it.
what-
Because you're taking spots away from Gary that he doesn't have to give. There's nothing in writing that we have in the file that he said he has. It's a non-conforming property because he doesn't have off-street parking provided. It's provided by him, not the city.
It doesn't say in the ordinance that it has to be provided by him. It just says it shall be provided.
That's what we ended up going ahead with.
Because it says each dwelling unit shall provide 1 off-street parking space separate from customer parking.
I think,
And that's apartment accessories to commercial use. So he doesn't have a parking spot to provide.
back up a second. You keep using the word he.
Okay,
I would
Dr.
prefer-
Ortiz does not have ample parking.
And so he contracts it
So he
from
contracted
St.
it
Peter.
with
Gary.
Gary St. Peter.
Yep.
Saying, you know, I've got a written agreement, I believe what he said, and we could look back, he says he has a written agreement with Gary to
Yep.
provide him 2 parking spaces
Okay.
for that.
Yep. So what's the
But Gary
problem?
doesn't have those spots in his property
So then who's
to
in
allow it.
so then who's in violation here?
Well,
It's not
in-
Dr. Ortiz.
In theory, both of them are. Because
Well,
Dr. Ortiz has 2 dwellings upstairs,
Dr. Ortiz has an agreement for 2 spaces.
but he
And so-
doesn't have those spaces.
Yes, he does.
We
He's
don't
got
have,
an
we don't,
agreement.
no, we don't have the agreement. That's what I'm saying. I mean,
Well, what you're saying is you haven't laid eyes on the agreement. So,
it's not in the file.
well, then all we need to do then is
And I
ask.
believe we told him that we needed a copy of that.
Yep.
But
well,
regardless of that, it still doesn't meet code.
Why
I
not?
mean, because he doesn't have the parking for it.
Wait a minute. You're saying
It
that
ties
regardless.
back to the same thing as far as the putting the residential use or the dwelling in that building that we were just talking about up off of South Main when facilities wanted to do that. It doesn't meet code. We didn't allow that then. We shouldn't have allowed this when it happened. Because Dr. Ortiz knew back in 2012, when he put his first apartment in there, that he needed parking. And he said he was going to do so by putting an overhead door coming off of Stevens Street.
That would be my question, because I have a building permit in the file for a 4-bedroom, or, 4-bedroom apartment and 2-bed garage, which was approved on April 23rd, 2012. Was any of that ever built?
The apartment was, but the garage never was.
They kind of gutted the inside of the building. The lower level, they just kind of took it out. He had it engineered to put in steel beams, to put in a floor system that As far as I know, they never got to the garage door part of it. But even, I think, Public Works had agreed to pull the granite so that they'd create a sloped access up over the sidewalk so they could put their vehicles inside of the building for the initial creation of the single residence that first went in.
So the permit was issued for a garage that was never built.
Part of the project of allowing Dr. Ortiz to develop or to redevelop the residence on the second floor in the C1 zone was that he was providing, I believe, a garage space inside of the building.
Right.
Coming in from Stevens Street. The buildings in the C1 zone, there's no setback requirement.
Mm-hmm.
And when you think of the ownership of most of the buildings in C1, they have, none of those buildings have parking.
Right.
And I think what we've identified, there are many empty spaces on the upper levels of the buildings on Sweden Street that potentially could offer residential dwelling units. And I think back then the planning board was trying to create a way that people could develop those upper levels, looking at other communities that have mixed-use zoning.
Sure.
Retail businesses downstairs during the day, and then residential dwellers living upstairs.
It's called new urbanist development in some places,
Good
so,
for the
yeah.
community,
Absolutely.
fees and security, so.
Yep.
But
I mean,
that was initially part of the plan.
Right.
That was approved by the planning board back then.
And I know Dr. Ortiz stood in front of us and said when he came for his most recent one, that they scrapped the idea for the garage doors and they were just gonna use Gary's 2 spots. I almost believe that's the point where, you know, he started getting a little agitated, but I mean, that, we approved it as a non-conforming property based on the way the code's written, because he doesn't have the parking for it. And that's what I'm trying to address.
Yeah, but-
I mean, the people who reside above the movie theater are provided parking. Now, do they park in the street during the summer? Sure they do. But they're provided parking, especially during the winter months.
So there's an apartment above,
It's software company.
yeah, but I'm thinking the one at the old Fitzgerald's office. Up above there.
Cubby.
there's-
Up
Yeah,
above
the
that.
Yeah, above the cubby.
yeah,
They don't
there's
have parking.
They don't have a parking, they
Nope.
don't have parking there.
Well, I guess my question would be then, what I'm hearing is that this use, this apartment, this accessory apartment was approved based on the idea that this building permit was being issued for the provision of parking in a garage.
Correct.
So that would have satisfied the requirement of providing parking for those residences,
Correct,
but
at that
that was
time.
not completed.
Correct.
But hold on, that's the 2012
Right.
thing.
Yes.
Now, he was here within the past year. The action that you're referring to is the one that within the past year.
Right, but he set precedent by not completing what he said he was gonna do with the first one. Had he put in 2 overhead doors there, he would've been covered. But he didn't put in any overhead doors there, continued using it as such. So I mean, in theory, before he came to us, that was still a non-conforming property because he hadn't finished everything.
I never would have known that until he came here in 2012. That was-
And I know that was a big source of contention with his neighbors at that time. I think if I remember correctly, I think the people who own the cubby came and said, well, wait, you're gonna chop up part of the sidewalk here and you're gonna take up parking spaces, you know, that the city provides, that are not her parking spots, but the city provides. And
Lose parking spots because of the driveway into the garage.
so when, in theory, when he came before us this last time, his property was still not conforming. So,
You know,
Can I add one more aggravating piece to this mix? I think that the parking in the downtown area is a whole dish of I don't know what, all in and of itself. I mean, because the city owns lots, people park where they weren't supposed to and used to get ticketed because they come in and they say, don't ticket us, and we be, oh, okay. And then, you know, we'll plow around you. So the whole area is, and it's very inconsistent from
It is.
one business owner to the next.
I agree.
I'm,
It's a city council issue.
well, no, I
Not
think.
all of it, not all of it. This part is our issue.
I don't know if, and I hate to incur legal expenses for the city, but I don't know if this is another Rick Solomon problem to look at the chain of events, because when we approved this in the past year, we were not aware that he did not complete the 2012 obligation of the garage doors.
He admitted
Oh,
it, Phil.
time out.
He stood right there and admitted it.
Getting a building permit does not obligate you to complete it.
Right.
Okay? And the other thing that I'm getting at here from a liability perspective is, and that's why I want to get legal opinion, is we gave him a go-ahead. And he turned around and spent money and made some apartments. Now, if we're gonna retroactively revoke that, we're liable for his
I
out-of-pocket.
didn't say to revoke it. I said we need to give him ample time in order to rectify it, in order to make it,
And what do you consider rectifying it? Putting in the garage doors?
finding a way for him to create parking for those 2 spots that he requires.
Now, he's gonna come back, I'm being devil's advocate here, he's gonna come back and say, here's my agreement.
Yep.
And with Gary St. Peter. Now, if you're maintaining that Gary St. Peter doesn't have those spaces to give out, then the problem isn't with Dr. Ortiz, it's with Gary St.
Well,
Peter.
it's still with Dr. Ortiz because he still doesn't have parking.
He has
It
a
starts
legal obligation, he's satisfied his obligation. It's now Gary that's left himself short.
And we don't know what agreement Gary has with the surrounding
And,
parking.
and as I said during the meeting that night, if Gary picks up his anchor, heads out of town tomorrow, and that person moves, somebody goes in and takes that business over,
And I mentioned that.
right, and that's when he started to get upset.
Yes?
I think that if you look at the whole process, that in that particular situation, some of the things that she just brought up that have been going on in the past would have been corrected had he built his first apartments and stuck with the design that he had said. It would have relieved this whole issue. The other issue is that if a person that's constructing something does not have property that he can provide parking, then there's another process there, I think, that actually you have to go to the zoning board in order to get off-site parking, to get approval for that. So there's just one element that may have been left out of that. And I'm not 100% sure of how that particular item works anymore, because I haven't looked at it in a long time. So, in essence, that particular process is not correct, okay? Because it's not just a handshake or anything like that, it's a controlled subject that needs to be dealt with here. And I think maybe if you research that a little bit further, you'll understand the whole process and it probably will answer itself.
Steve, do you have any wisdom for us?
I do. I see this as an excellent opportunity. Planning board members have identified that Caribou has an issue with the C1 zone, dealing with mixed uses during the day for people coming in to hit the retail stores and all. But if people are residing in the buildings that do not have physical square footage on their parcels of land that go along with the building, there's definitely an issue that would be a problem for people that own vehicles that would like to rent apartments in the C1 zone. Being the C1 zone, it's the opportunity for the planning board to rewrite the ordinance to allow people that don't own automobiles, maybe they own a bicycle or a skateboard, or however they get around, but everyone doesn't have to have an automobile. This would be an opportunity for the planning board to create an ordinance that then allows those buildings to have residential occupancy without parking being an issue. So quite often, the ordinances that were purchased by the municipalities years ago, let's say in the 1980s, in today's times, it could be that things have changed and everyone doesn't have to have an automobile. So here's a chance for you to take that ordinance apart, fix it, and put it back together so it makes sense for the community in the C1, the downtown C1 zone. The planning board is in a position to create new ordinance revisions and provide them to the council, for the council then to adopt. The planning board can fix the problems. You have the power.
I'm not convinced
Well,
that's the problem that needs fixing.
Well, but we can't continue to allow past practices to set precedents for what we're doing. And basically, in theory, that's what we did. Because given the lack, let's say, of experience for the board at the time when he came in, and our lack of depth of knowledge, per se, or not doing our homework for that particular issue, I mean, we created a problem for ourselves. Because the next person can say, well, you let him do it. You let him do it. And you let him do it.
Well,
Which
would
is
you
be what we ran into with regards to the facilities project.
I guess, would it be helpful if we did some research of the minutes of the planning board at the time of the approval for his site design application for the residential apartments?
For the
that-
first one?
That apparently, at that time, the way I'm looking at the material that I've looked at for the last couple hours, so I need a lot more time to really get into this in greater detail, but it appears to me, from what I've heard, is that the gentleman came in, was given approval to build some apartments that were going to be supported by interior parking that then he didn't complete.
Correct.
So from my perspective, just hearing that, it tells me that, yes, he got a building permit that he may not have been required by law to complete from the perspective of it just being a building permit that was issued, but that if that was part of a conditional approval of a residential use, accessory use in a commercial building in a zone that required that, then he didn't fulfill his obligation to this body when they gave him that approval, based on the idea he was going to provide parking inside the structure. That makes sense. Because he hasn't provided the inside parking.
Correct.
And now he's come back to you with the idea that he's going to secure the parking spaces that he didn't provide in the building by renting them from a neighbor. And you're telling me that the neighbor doesn't have enough spaces to allow him to do that.
He doesn't. Because I think required parking.
I wouldn't say that
spaces-
that transfers his problem to the person he's trying to rent spaces from. That's still his problem.
Right. It still
So-
lies with him because it's his
Yeah, I
property,
mean,
it's not conforming.
I'm
It's not
happy
his
to ask
neighbor's.
him, if you'd like me to, I'm happy to ask him for an agreement with, I wrote down Napoli's, is that Gary St. Peter?
Yep.
Yes.
Okay, so I can ask Mr. Ortiz if he has a copy of the agreement that he has with Mr. St. Peter, if that in fact turns out to be satisfactory for solving his problem by not building his interior parking.
Well,
By extension, we need to determine that the spaces that Mr. St. Peter is gonna loan, sell him, rent him, lease him, whatever, provide, are legally available.
We need to find out if they even exist now that
Right.
he's built that deck.
Right, I mean, that's where I'm going with this,
Right,
is that there's
because
a
rega-
cascading effect, from my perspective, and I'm not an
That's what
attorney, and if you'd
I'm
like me
looking
to,
at a cascade.
if you'd like me to
Well-
secure some legal counsel advice, I'd be happy to do that,
Because
but
the-
I'm seeing it as a cascading effect,
Well, let's
ultimately going back to the original applicant.
Yeah.
let's
and the
hold off on
conditions
the
placed.
on the legal costs
Okay.
until you do some research. Steve?
If a property owner makes an arrangement with another property owner, that would be a civil issue between them.
Right.
The planning board should stick to your ordinance, and the ordinance does not support the planning board endorsing a civil agreement between two property owners. The planning board should stick to the ordinance. It's advised the planning boards not to become involved in things that are not ordinance related.
So you're saying that the agreement for the spaces to be obtained from across the road doesn't hold water?
It's not material.
Just like a covenant in a
Right.
subdivision,
Right.
planning boards should not become involved in an attempt to enforce covenants, being that covenants are not part of the ordinance. If one property owner makes an agreement to use space on another's property, and then that person sells the property, the next owner potentially would not endorse or honor that. If it were actually written as an easement into the deeds and recorded in the registry, in effect, that second property owner would have sold to the first property owner rights associated with the second property, and then to be recorded at the registry.
Well, Jim will research the 2012 as well as maybe the 20, was that in 15 or
It
16?
was this year. I think it was either this year or the
2016.
first part of the end of, yeah, I think it was January.
And
maybe.
come back to us next meeting, if that's
Sure.
achievable.
I know that we passed this based on the wording of this ordinance, which was, each dwelling unit shall be provided with. It doesn't say where you're gonna get it from. The same thing with C, each dwelling unit shall be provided. You know, like, they're provided with it according to what he said. It doesn't say in here it has to be part and parcel
Exactly.
of
It
the
doesn't say it
property.
has
So
to
we
be on the
can't,
property.
getting into it, maybe at the time it could have been, more strictly done, but, this is going back, and this is what our decision was based on at the time, is the wording of this ordinance.
And I would say that C, each dwelling shall be provided one off-street parking space separate from customer parking.
Right.
The way I would interpret that is that the obligation is on the owner, the landowner, to provide parking spaces
Correct. Because
on private property. Off-street, to me,
It's private
indicates that
property.
it's private property,
But it
that they're
doesn't
not going to be able to extend the,
because
they're not going to be able to claim rights to a parking space that's provided on a public lot to
Exactly.
satisfy this requirement.
Exactly.
That's,
Well,
that's
that's
clearly not
something-
the intent in other places that I can tell you, that other ordinances and other
I understand the
jurisdictions.
intent
A
issue.
rational,
Yeah.
But the way
a
this is
rational
written,
person would
there's
think
there's wiggle room.
public parking or off-street
Yeah, there
parking.
is.
Off-street parking to me is personal. Public parking is what we have at, North Mall, South Mall, Hatch Drive. That's public parking.
See if there's a definition for it in them.
There's
I know
no
we've got
mention of
several
public
places where we
parking.
have definitions.
But in here, it says, under C, it says off-street parking. Off-street.
Separate from customer parking, doesn't
Right.
say it can't be public parking.
No,
But
it doesn't.
off-street, a rational person would think that it's something that's not owned by a municipality.
Bill?
That's your interpretation.
Steve?
Michelle's comments a second ago justifies why the board did what the board did. But I think what Michelle brought up, again, just helps to make the point that much stronger, that the ordinance needs to be more specific.
You're right.
It needs to be rewritten.
So
You're right.
I think what the board had done, they made a decision that, okay, someone's going to make me, you could park up at some place up on Sweeten Street or Bennett Drive, or I could rent somebody's space in my driveway if they lived on Sweeten Street. It's a little bit of a walk, but,
There's language in there, that's what I was trying to say, there's language in there covering that same thing, that you have to seek other approval to do that.
So if the board rewrites the ordinance dealing with parking, and the issues are always in the C1 zone, being that there are buildings that have no exterior space for parking, you can create a nice ordinance that makes that work for our downtown.
And I'll interject that the definition of a parking space in our code, it's here. It says an area on a lot. Now, I would read that to mean on a privately owned piece of property, on a lot, intended for the use of temporary parking of personal vehicle, period. The size of each parking space shall be exclusive of drives or aisles for the parking of vehicles, and have a means of access to a public street. So those two sentences tell me that a parking space by our code is defined as a piece of the property on a privately owned lot that is designated for putting a vehicle, and that the vehicle has to have access through aisles and lanes and other whatever means of ingress and egress are provided to a public street. So that means to me that you can't designate a public parking space as satisfying the requirement of a parking space if a parking space is required by code. That would be my interpretation. I'm happy to have that backed up by others and legal counsel, but does that make sense to you?
Yeah.
The way I read that?
That was written 36 years ago.
The rewording to make this a little stricter should reference that.
Well, and it doesn't necessarily have to make it stricter, that's the thing, it's where's the need? Maybe the parking thing will start here, but from what I understand, it's dead, Jim. You know what I mean? Like, we can restrict how it goes, or make it fit what we want Caribou to look like, but as far as making it stricter, that might not be the way to go.
I agree with that.
But in certain areas, we may want to make
Right.
it stricter.
Right.
And that
And it
being one of
depends
those
on-
particular areas. If we want to make that downtown thrive,
Right.
then, not saying that we need to boot everybody out who's living upstairs or whatever places they're living down there, no. But we need to make sure that it works And right now, it doesn't.
Well, you say it doesn't.
Well, I mean,
The tenants are happy.
well, define happy.
They have a place to park.
At your expense.
It's not my expense.
Sure it is.
Yes, it is.
Yeah, it is. It's at your expense.
Why?
Because they're plowing, their driveway's being plowed by your tax dollars.
Well, my sidewalk isn't. It used to be, so we're even.
So. But it's
Okay,
at your
I guess,
expense.
I would applaud Mr. Wentworth's thoughts and ideas about the idea of, this is an opportunity, and it's certainly part and parcel, which is one of the reasons why I included it as part of the Chapter 13 review process, other business, because to me, that's where this fell. It's just a continuation of the discussion about how we can rework our Chapter 13 code and improve it. And certainly, if we have mixed use as a desire for the downtown area, then we need to figure out what the formula is for providing the opportunity for residential units that may or may not have, as part of their approval, a requirement for an off-street parking space. And if we do that, then by doing that, we would not be giving them permission to have a parking space dedicated to their use. There's a public parking lot, and they can park in a public parking lot. So it's kind of playing it both ways.
But street rules.
By having a public
apply.
parking lot, we're taking on the obligation, the city, to maintain that and have it be open and accessible to anyone who wants to use it. And we're not going to try to differentiate between a customer for a retail establishment or someone who's living in an apartment over that retail establishment. Once we reach the problem, and I don't know that we have, once we reach the problem where all of a sudden we don't have enough parking spaces to satisfy everyone's need, and the parking is now encroaching on the neighborhood streets adjacent to the area, which is what you see in a lot of communities, particularly that have universities, where the universities have kids who want to park their vehicles, they don't have enough parking spaces, they start spreading out into the neighborhoods. Then you start seeing the parking permit required in the neighborhoods and restricted parking on neighborhood streets. We don't have that problem here. Perhaps it would be nice if we did, but I'm just throwing that out as an idea that,
We'll never have that problem in the winter.
yeah.
Okay, so you'll look it over and get back to us.
Absolutely. Would you like a recommendation for anything specific with regards to this particular landowner, or just generally?
Well, we need to find out, number one, is he in error in not following through with the 2 garage doors? Because if it appears that the approval that was granted for the first residential unit was conditional upon those doors, that's issue number one.
Yep, I agree. And I'll see if we can find planning board minutes that reflect language associated with any conditions at the time of that approval. So, I seem to recall that I've been down this particular rabbit hole before as a result of someone's making a request for a city council discussion of the parking downtown. And I don't recall finding anything then, but maybe it's a different topic. Is it a different topic? You know what I'm talking about? I mean, we did some of this research and we had this discussion last winter about the parking lots and the plowing and.
Yeah.
Okay.
Nobody wants to talk about it.
I'll look into it. I'll look into it.
Any other business to come
I'll call you
before
tomorrow
us?
and refresh your memory.
Any other business?
The only thing I'd like to mention is if we could get our packets on Friday,
Yeah, before the weekend would be.
because
Sure.
it's too difficult for me, and I don't know about you guys, but
Okay.
it's too difficult for me to
To read
To read
things?
everything.
through it. I mean,
Yeah.
I can't do it from six in the morning till 7 or 8 o'clock at night, so it's
Okay.
it's tough, so.
Sure. My goal is always to try to get them out the week before. You know, either a Wednesday, Thursday, or Friday the week before the meeting. And there's times when we've had to do that to meet statutory requirements for other mailings and all that, but yeah, this time it didn't happen, so I'll do my best. Yeah, I'll get them out by
Chair,
Friday.
need a motion to adjourn.
Yep.
Turn the chair, just adjourn.
Good question. I asked for a motion to adjourn, and he said that he doesn't think that I need one, that I can just declare adjournment.
Oh, that depends on how strict you're gonna follow Robert's Rules of Order.
I'm Robert.
Well, I can
Robert
certainly
just
look
said
and see
that
what
I
the
can
bylaws
say
are
this
with regards to
meeting is
the procedural guidance that the charter
to
and
keep
the
you happy, I
ordinances
move
give
we
the planning
adjourn.
board. Because it's probably in the ordinance somewhere.
Okay, we got a motion and a second to adjourn.
That's been our
Unanimous.
practice, so, yeah, okay.
And we turn off the mics at 6:40.